So the topic of our session this afternoon is, of course, charity law and transition. Many of you will be very aware that we are putting the finishing touches on bringing the 2023 Act into force, and that's really going to be the focus of our presentation today. But before I pass over to Claire, who's going to take us through a number of the details about the changes that are being brought in, I wanted to take this opportunity to reflect a little bit and take stock about kind of how we got here. Just to say also that we will leave some time for questions afterwards, and we're grateful to those who submitted questions in advance. So a couple months from now in April, OSCR is going to celebrate its 20th birthday. And so it means that it's been 2 decades since the Scottish Charity Register and the regulatory framework that we work within came into being. And that's all really familiar to us now. And for the most part, it's been really fit for purpose in a lot of ways. But we also know that while it was visionary at the time and was really kind of ahead of other jurisdictions at the time, a lot has changed. Charities, yourselves, the communities that you serve have changed, and the risks and challenges that you face have also changed, and we need to be responsive to that. So the 2023 Act gives us a really vital upgrade to be responsive to those societal changes and also bring Scottish charity law into line with what's happening in other UK jurisdictions as well. It first of all addresses the public expectation to be better informed about charities, and we'll talk a little bit more about transparency later. But crucially, it also provides us, OSCR, with essential new tools to regulate charities and charity trustees effectively. And to me, it's really serendipitous to be here today to be able to take stock at this time around this kind of coinciding with our landmark birthday, so to speak. So the new Act has been kind of in progress for about 10 years, actually, and I'm really proud to say that a lot of the provisions within it are based on recommendations that OSCR originally made. But I also want to acknowledge that countless people had a role in bringing it to fruition. And so I really want to thank and acknowledge the charities, professionals, academics who engaged with us in public engagement events or responded to public consultations. I want to acknowledge our Scottish Government colleagues who safely guided the bill through Parliament. Everyone who assisted us with user testing and user design of our new systems. And finally, those of you who are here today to learn about it and are going to be able to spread the word about the changes that are coming into force and helping support the sector in meeting the new compliance requirements. So I'm just going to speak briefly to this slide before I hand over to Claire, because making and enforcing law is never a kind of end in and of itself. Things are constantly changing, and it's important to reflect on why we need this new law. So first, to speak to the first one, the huge contribution that charities make to all aspects of Scottish life are dependent on the support and goodwill of the public. In our past opinion surveys and others, if people were at a session earlier today, shows that that support and trust remains pretty solid, but that we can't take it for granted. And we know, because the public tells us, that having information about charities makes a big difference to people's choices about whether and who they support. Knowing how a charity is run, how it uses its funds, who is running it, can be a deal breaker for some people. So there are a number of measures in the new law aimed at increasing the transparency of charities and accountability of their trustees, and we'll get into a bit of that detail momentarily. By the same token, people need to have trust in OSCR. They need to be confident that the regulatory regime that we are upholding is sufficiently robust and that OSCR is up to the job. We must regulate and be seen to be regulating effectively. The 2023 Act, very importantly, gives us new powers to be used in a targeted and proportionate way. We can make inquiries and, if necessary, intervene to protect charitable assets and the integrity of the sector. And by fixing kind of certain issues that we've experienced with the previous legislation over our past 20 years, the new law also helps us to work more efficiently, streamlining and simplifying processes to make the best use of public value. So these two first aims contribute to the third, which is about keeping charities safe from harm. By that, I mean protecting the sector from anyone seeking to exploit it for private benefit or other unlawful purposes. The law gives us, as OSCR, the ability to collect additional information about charity governance, contact trustees swiftly, and have new rules on trustee disqualification, which will all help us to achieve this third aim, and that disqualification piece is something I'll talk about shortly. Now, charity law and transition, going back to the title of this presentation, does suggest to me kind of a journey rather than a final destination. There are always improvements that we can be making, and we need to be responding to the challenges that are faced by a sector that, quite rightly, won't ever be standing still. So it feels like a really great time to be taking stock, reflecting on where we've come from, but importantly, the changes that we all are going to be experiencing together as we move forward. So thanks very much as we celebrate this birthday, and I'll hand over to Claire for a bit.
Thank you, Alex, and good afternoon, everyone. So over the next 20 minutes or so, we will take you through the key changes in the regulation of charities stemming from the 2023 Act. Most of the changes are now in force, and those outstanding are expected early this year. But before we do that, I wanted to share this slide with you all. It shows the timeline of charity law in Scotland since OSCR was established and the present framework for the registration and regulation of charities began. It's important to keep in mind that the 2023 Act does not repeal or replace any earlier law. The principal legislation for charities in Scotland remains the Charity and Trustees Investment Scotland Act 2005. Minor but important additions were made to it in 2010 through the Public Services Reform Act, but the 2023 Act is the most substantial updating we've had so far. It consists entirely of additions and amendments to be inserted into the earlier legislation. Therefore, when we talk of the new measures being introduced, it's more accurate to refer to them as provisions of the 2005 Act as amended, rather than provisions of the 2023 Act. So think of it as an upgrade, modernisation and improvement, rather than a standalone piece of legislation. But not everything has been amended. So before looking at what's new, let's look at what has not changed and what remains the same. Firstly, the charity test. The test by which OSCR determines whether a body can be registered as a charity remains the same. Charities must still have wholly charitable purposes, and they must provide public benefit in furtherance of those purposes. The registration process too is the same, except for two very minor differences. The amended law now permits two charities on the register to share the same name, but only when this is a temporary transition to a different legal forum. So this would be applicable if somebody's incorporating as a SCIO from an unincorporated organisation. The second change is that OSCR must now refuse to register a body if it has no or only a very negligible connection to Scotland. Charities are still required to obtain our prior consent to amend their name or purposes as before, or if they're seeking to amalgamate or dissolve. The only minor change is the removal of the former requirement to give 42 days of notice of their intention to do so. Charities must continue to complete an annual return and send accounts to us each year, including an annual report. But the completion of the annual return, which has always been an OSCR requirement, is now made mandatory by the legislation. And the requirement to include the independent scrutiny report when submitting is also clarified in the new legislation. Finally, the general duties of charity trustees are unaffected by the changes. Trustees must still act with due care and diligence in furthering their charity's purposes. They must act in the interests of the charity, and they must manage any conflict of interest appropriately. So moving on now to what is new. I said at the outset that most of the changes are now in force. Commencement of the 2023 Act has been phased, and this slide shows you the dates when the changes were made or remain to be introduced. We will run through them in chronological order, beginning with the changes that commenced on the 1st of April 2024. On that date, OSCR acquired a number of important new powers of inquiry and intervention that complement the suite of powers already available to us. The second phase of commencement took place in the summer of 2025, and we are now preparing for some further changes in the coming months regarding information which will be published on the Scottish Charity Register. The most significant new measures that came into force in April 2024 are shown on this slide. They centre around OSCR's powers to make inquiries, to issue directions and to intervene into a charity's governance. They also permit us to remove charities from the register in certain circumstances. We now have the power to make inquiries into former charities and former trustees, and this closes a loophole in the legislation through which a body could previously have evaded inquiry by requesting removal from the register, or an individual just simply by resigning office. In relation to current charities under inquiry by OSCR, we now have a new power to direct them to take specified steps. We may use this power where we have identified misconduct in the administration of a charity, or where we consider it necessary to protect charitable assets or to secure their proper use for charitable purposes. Prior to the 2023 Act, our powers of direction were largely preventative, meaning we could stop charities or individuals from doing something if we considered their assets to be at risk. This new power to direct charities to take a positive action is a very valuable addition. In the past year, for example, we have used this power to direct a charity to hold a general meeting of its members, as required by its constitution. And this was for the purpose of appointing a new board of charity trustees to put an end to a long-running internal dispute. This new law also gives us the power to appoint interim trustees in certain circumstances, and this is either by ourselves or on request from the charity. This will be really valuable where a charity has insufficient or no remaining charity trustees or none willing to act can be found, and where a charity's constitution does not provide a mechanism to allow them to make the appointments themselves. I should stress, however, that these instances are limited, and this should not be thought of as a solution in a case where a charity has the means to appoint the charity trustees itself and is failing to do so. There are also practical challenges for us in identifying individuals who are willing to be appointed, and we are still considering the best approach how to bring this into action. Of the new measures granted to us, the one which we have made the most extensive use of so far is the power to remove charities from the register where they fail to file annual accounts with us and fail to engage with us. And I'll talk about this in a bit more detail in the next slide. But I will just mention in passing here that the requirement for charities to have a connection to Scotland that I referred to earlier does not just apply to new applicants. Charities who are already on our register must maintain that connection to Scotland, and OSCR must direct them to establish a connection if necessary. And if they fail to do so, we must then remove them. This affects a very small number of charities, and we have been able to engage with them individually. And just to be clear, this doesn't apply to charities who provide benefit overseas but clearly have a base in Scotland, or those who are registered as cross-border charities in England and Wales and genuinely undertake activities into Scotland. As I said, we've made extensive use of our new power to remove charities that are in default of the requirement to file annual accounts and that do not respond to our reminders and notices. So to date, we've removed close to 600 charities using this new power. Removal is always at our discretion. We carefully consider the risk and the last known asset level of a charity prior to removal. The charities we have removed have been small and in many cases registered with us and then really failed to progress to make any activity. We do not remove charities where we understand them to hold heritable property, and the new question on the annual return for smaller charities helps us to be clearer about which charities do hold property. The amended legislation requires to give 3 months' notice to a charity of our intention to remove it. And if the charity responds to this notice, then the process is halted. So if we re-establish contact, we can use other measures to reach out to that charity. We serve the notice to the last known contract address for the charity, but we also publish it on our website, and if we need to, we can post it elsewhere as well. The figures confirm that the use of this power has really been a success. Before commencement, the proportion of defaulting charities was over 12%, and now it's around 8.9%. It has been lower, fluctuating depending on the time of year. So this means the charity register is more up to date. It contains information about active charities rather than those sitting dormant, and this makes it much more useful for the public to use and engage with. At present, we can't use this approach with SCIOs, as removal from the register would have the effect of dissolving the body. Defaulting rates among SCIOs, therefore, are slightly higher at over 12%. Last year, the Scottish Government consulted on a proposed amendment to the SCIO regulations that would address the problems around removal of SCIOs. Its analysis of responses to that consultation have been very recently published just last week, and we welcome the Government's commitment to lay new regulations by the end of this calendar year. One of the significant changes to affect all charities is the new duty placed upon OSCR from 30th of June last year to maintain a schedule or database of all Scotland's charity trustees. Once fully populated, we expect the schedule to hold data for around 160,000 current charity trustees. Charity trustees are responsible for the management of the charity, and they are the custodians of its charitable assets. They are the people we hold to account for the activities and operation of a charity. But until this new law came into force, we had no direct means of contacting them. We relied upon the principal contact to make contact, and that wasn't always a charity trustee. Since 30th of June last year, charities have been able to add details of their charity trustees through OSCR Online. OSCR Online is the portal that charities currently use to submit annual returns, so people should be familiar with using that. We've been actively encouraging charities to begin registering charity trustees as soon as they can. This ensures they're up to date and prepared for the new requirements. For all annual returns which are issued on or after 30th of June 2025, charities will need to complete their charity trustee details before they can submit that annual return. Each charity can have 3 users in OSCR Online who will be issued with a password allowing them to log on to the system. And we encourage charities to always ensure they have at least 2 users registered. This means that if for some reason somebody's unable to access the system and do the necessary updates, there will be somebody else available. Most of the data we are collecting on the charity's trustee schedule is for OSCR's internal information only. And we are asking for the following information: the first and last name of each charity trustee, a contact address, telephone number, email address, their date of appointment and date of birth. This means that we can contact trustees if necessary when carrying out our statutory functions. We can contact all charity trustees in the event of an inquiry or if a charity is overdue with its filing requirements. It will also allow us to build a much fuller picture of Scotland's charity trustees, ensuring that we really meet their needs and our guidance is appropriately targeted. We don't undertake any verification checks on the information entered, so that's reliant on the charity user to get it correct. We ask for a charity's trustee's date of birth, as this allows us to make a basic differentiation between different charity trustees with the same name, and it means that we can better understand if someone is a charity trustee of more than one charity. When a charity trustee ceases to hold office in a charity, this information should be recorded with a reason for ceasing to act. Once the charity trustee has been removed, we will hold their information internally for 2 years after the date of removal. Once the initial charity trustee details have been entered, we require this to be kept up to date with any changes, such as new appointments, resignations, or changes in contact details or name. Charities officially have 3 months to make these updates, but we would really recommend doing so as soon as possible to ensure the information is up to date. In time, we will commence publishing trustee names on the charity register, and I will say a bit more about this later. Trustees have every right to expect their personal data to be held and processed securely, and we take data protection and cybersecurity very seriously at OSCR. All our staff undertake data protection training annually, and we have regular cybersecurity checks. Our work laptops, tablets and mobile phones are all encrypted to prevent unauthorised access, and access to our internal systems is restricted to OSCR staff only, and staff are assigned specific permissions to view, enter and edit details based upon their roles. And you can read more about our data protection commitments on our website if you're interested in understanding that a bit further. So what have we found so far with the trustee database? We've been really encouraged by the level of compliance with trustee registration so far. At the end of January, we'd received data from 13,290 charities, meaning we hold data for 84,810 current charity trustees, and that's over 53% compliance. It's quite far ahead of where we really expected to be by this date, so we've been really pleased. We hope in time to extract some useful demographic information from the data we collect, and this will help inform our stakeholder engagement and guidance. Some of the findings are much as we expected. For example, the median age of a charity trustee is 61, appearing to confirm our predictions about an ageing charity trustee population. However, our youngest charity trustee registered is 16, and the oldest, a remarkable 108 years old. We have learned that the average time that charity trustees serve for is 7.4 years, and there are 5 trustees per charity. But the largest trustee body so far has registered over 256 charity trustees. And I'll hand back to Alex at this point to talk about the circumstances where someone might not hold office as a trustee.
Right, thanks, Claire. I'm going to be talking about when a person is not allowed to act as a trustee. And this is related to the automatic disqualification of trustees, which means that it is not about, say, asking OSCR whether they are allowed or not, but is the responsibility of the trustees and the management within the charity itself to know these rules. And I'll say now and again later that we have detailed guidance on our website for this. It is one of the most extensive changes that we're talking about today. So please do look at that, because whilst we expect that this will only impact a very small number of charities, it has the potential to affect any charity in Scotland. So this is the kind of big change from April 2006, which is when this part of the 2005 Act came into force, to the kind of extended, clarified, and modified, essentially, criteria about automatic disqualification. So trustee disqualification obviously isn't new. You're likely all aware of the previous criteria as well. The changes that we've made are largely about bringing Scotland's legislation into line with other UK jurisdictions, and also responding to other related kind of criminal legislation that has been updated since the 2005 Act. This is really an important modernization to this part of charity law. So as we go through, on the left, those will be criteria that you are likely familiar with, but you'll see that some of the new criteria on the right, where we've tried to summarize these, are related to, for example, unspent convictions for specific offences involving financial crimes, such as bribery or money laundering. Other changes relate to individuals who have been found to act dishonestly, for example, related to fraud, embezzlement, or perjury, or otherwise negligently. Also new is a disqualification of individuals subject to special reporting requirements under sexual offences legislation. So the information again on this slide is brief, but I would very much recommend you check out our guidance online, which also has a very useful flow chart if there's any confusion, but also we would recommend also taking advice if required. So the other significant change to the rules on disqualification is about the extension of these rules to senior management functions within a charity. So this is no longer restricted only to charity trustees. We've set out how the law defines a senior management function. This is, again, about the function itself, not so much the job title. And there are two ways that this might apply to an individual. So they may have at the top the two kind of pink and green boxes here. It may be that they have responsibility for the management of a charity and report directly to the trustees, or alternatively, have control over a charity's finances and report either directly to the trustees or to a senior manager. So in practice, this is likely to apply mostly to a chief executive, for example, or a chief financial officer. But it may be that in a smaller charity, this might be a volunteer. And so again, this is about the function rather than the job title. To avoid any doubt, I should also make clear that this extension to senior management also applies to those criteria for disqualification that were set out under the original 2005 legislation, not only the new extensions in the 2023 legislation. And on a somewhat kind of serious note, I will have this reminder that it is a serious criminal offence to act as a charity trustee or a person with a senior management function in a charity when this person is disqualified, and if they are doing so, they should stop immediately. Most of the grounds for disqualification are quite clear and leave little room for doubt, but if there is any uncertainty, please do stop acting and take advice as soon as possible. Now, fortunately, the law does empower OSCR to waive a disqualification in exceptional circumstances, and we have a form on our website to do so, to apply for that waiver. For example, there are really important and interesting cases where, for example, a person with an unspent conviction who has experience of a custodial sentence may provide really important insight and experience to a charity who is supporting prisoners, and they wouldn't be able to bring that experience and insight without that lived experience that they have. Now, each case for a waiver is assessed on its own merits by OSCR. We have our guidance again on our website about the types of things we take into account. We would be concerned, for example, of the interests of the charity, and we would be seeking a supporting statement and evidence from the charity concerned. For example, evidence that the trustees have carefully considered why this person should be in a trustee or senior management function as opposed to acting as a consultant, for example. So we will take into the account the circumstances that have led to a person being disqualified as well. And so this really is a very bespoke assessment that OSCR would make and would do so very carefully. But we're glad that we have the powers to consider those, given the insight that certain people can bring, for sure. I'll hand back to Claire. Thanks.
Thanks, Alex. So, as I said at the outset, there are still some changes introduced by the 2023 Act which are not yet in force, and these are dependent on Parliament passing the final commencement order for the legislation. Unfortunately, we're not yet able to confirm the exact date for that, but it will be in early 2026. The next set of changes will be the inclusion of additional information about charities published on the Scottish Charity Register. From the date of commencement, we will publish the first and last names of each charity's current trustees as part of its entry in the register. So we will not publish any of the other details we're collecting. It will only be the charity trustee's name, and it will only be current charity trustees. So if you resign as a charity trustee, your name will be removed from the register. We're also using the opportunity to include some additional information on the register that we've been collecting through the annual return form recently. And the information is the activities that a charity undertakes. So we're now asking a charity on their annual return to describe in their own words what activities they undertake. And this will now be published on the register entry. We think that will be really useful for the public to understand. At the moment, it just has some information about purposes and beneficiaries. So I think this will be able to give members of the public a really clear understanding of what a charity is set up to do and what it's doing. We're also going to publish the number of charity trustees, the number of staff members and the number of volunteers. The volunteers is in banding, so it's grouped 1 to 50, 50 to 100, etc., and it will be the banding that's published. In a moment, I'll show you a mock-up of what that will look like, and that will let you see just how that will be going forward. It's important to note that we will not publish the name of any person who we've granted an exemption from publication. And an exemption can be granted when the safety or security of a person or premises would be jeopardised by their name being published. When a charity user enters the trustee information in OSCR Online, they are asked to indicate if the trustee intends to apply for an exemption. And then after this, the charity trustee or someone on their behalf have 28 days to submit an application to us. The application form is separate from the entry in OSCR Online. And the reason for this is because the applicant may have sensitive information that they don't wish to share with the charity user. So by doing this form separately, it gives them the space and privacy to communicate this information to OSCR. We need the applicant to tell us enough information to understand why the safety and security would be jeopardised. But we don't need full details of traumatic or difficult incidents or sets of circumstances, only enough information to allow us to understand the context and make an informed decision. When we do receive such an application, we will ensure that nothing is published until we've reached a decision and communicated that decision appropriately. So it may take us some time to reach a decision, but be assured that that will not be published while we are considering our decisions. From the same date, we will begin publishing accounts for all charities on the register. So at the moment, we only publish accounts for charities which are registered as SCIOs or who have income of over £25,000. And at the moment, we publish with redacted details, so we take out all the personal information from the accounts. Moving forward, we will publish the accounts exactly as you send them to us, so without any redactions and without any checking by OSCR. The responsibility lies with the charity to ensure that these accounts are ready for publication and that you have the necessary consent to publish any of the personal data which is contained within those accounts. We are advising charities to really carefully consider what information to include, particularly names, photographs or information about children or vulnerable beneficiaries. We've always encouraged charities to tell their story through their annual report, and this remains the same. It's just ensuring that you have those permissions in place and that anything you publish is compliant with data protection legislation. The trustee's annual report must still include the name of the charity trustees, and this will be published as part of the accounts. But if a charity trustee has been granted an exemption, then their name should be omitted from the accounts. Again, this is the charity's responsibility. So if a trustee has an exemption, then you should remove their name from the accounts prior to submitting them to us. When you go onto OSCR Online to submit the annual return, it will come up with a reminder to say if somebody has an application or has applied for an exemption. Independent examiners will need to include their contact name and address. And that's required by the legislation, and this information will be published. It will not be redacted. So it's important that you understand this and communicate that to the independent examiner, particularly if they're using their own personal address. And just for clarity, we will accept typed or electronic signatures, and we do actually recommend the use of this because it ensures that your signatures remain secure. So typed and electronic are absolutely fine. So this next slide is a mock-up of how the information will be presented on the register entry. So you can see that the charity trustee names will be displayed with first and last name and no other information displayed. If someone has an exemption, their name will simply be excluded from this page. And there is a note on the register entry, which you can see at the bottom, that explains that sometimes names are excluded, and this will help users understand that sometimes the number of charity trustees might not correlate with the number of names that they're seeing on that register entry. And this slide just shows how the other information will be displayed. So you can see the section at the top, which has the details of what the charity is set up to do, and this will be populated with whatever's in the annual return. So it's important that you can give consideration to this, because it will help funders, beneficiaries and the public to better understand the activities your charity is undertaking. And you can also see here the numbers of staff, charity trustees and the amount of volunteers in the bandings. So what can you do to prepare yourself for these changes? So firstly, it's important that you understand who your charity trustees are and you start to register their information. It might take some time to collate this information depending on the number of charity trustees. So with a charity who had 256, I imagine it took them quite a bit of time to get that information together. So you should ensure you start collating that as soon as possible. Ensure your accounts are publication ready. Consider what you need to include, where you will need permission to include it, and what you might decide you wish to leave out. We do see some sets of accounts where charities tell us who's received grants, for example. Depending on the nature of those grants and the reason that they're received, people might not be happy with that information being included. So really have a think about that. And also make sure it is your accounts that you're sending to us. We also receive information from charities such as bank statements and things. We don't want to receive that. That will go straight on the register entry, and you really don't want your bank details to be up there in the public domain. We are going to run a webinar on the 3rd of March just to remind charity trustees of smaller charities of their accounting requirements and to get publication ready. So you might want to consider signing up for this, and you can do so on our website. Ensure that everyone is clear about the disqualification criteria and apply for any waivers if appropriate. You might need to update your governance and induction procedures to ensure that you've captured all the relevant information. Our guidance is already there on our website, and you should familiarise yourself with this. And any updates about when we will start publishing, any future changes, will be on our website and in our OSCR reporter. So you can ensure that you're keeping up to date, and signing up to our OSCR reporter is the best way for doing this.
So I hope you've enjoyed the run through of all the changes. I hope you're not daunted. Please do let us know if there are any questions, concerns. But we are looking forward to kind of starting this part of the journey together as we bring the final aspects of the 2023 Act into force. So if you do have anything that occurs to you after this, please do come and speak with us. There are others who also have other areas of expertise. But if that is it, then we will wrap up. Great, thank you.